So let's begin with the AM news now. And he was facing serious jail time accused of stealing, leading to the collapse of Capital Bank that left hundreds with locked up funds and even more without jobs. Ato Essien, who founded the bank, had fought the charges for 3 years, insisting he's innocent. But it turned out in court on Thursday that a day before an Accra High Court will seal his fate, Mr. Essien managed to convince state prosecutors to accept a settlement agreement with that will see him escape jail and rather pay 30 million cedis now, 60 million cedis later. But the judge rejected the deal, slamming state prosecutors and insisting they appeared compromised. The judge was clear the settlement was simply a bad deal for all who lost monies and affected by the collapse of that bank. My colleague Kwajo Nyako was in court and has more in this report.
The presiding judge, Justice Che Balfour, couldn't hide his dissatisfaction at the time of events. He was supposed to deliver his judgment on Thursday, but he says the court was served with a document detailing an agreement reached between the state and Ato Essien, the founder of Capital Bank. In the agreement, William Ato Essien was to pay 30 million Ghana cedis, while the remaining amount was to be paid in 2 installments, but the judge disagreed with the settlement. He referred to Section 35 of the Court Act, which he says relates to an offence that has caused economic loss or damage to the state, but in the instant case, the funds belong to the shareholders and not the state. Justice Che Balfour also stated that the offer and acceptance by the two parties based on Section 35 of the Court Act should be subject to the concurrence of the court, and in the instant case, the court does not agree to the proposed settlement between the two parties. According to the judge, even if it were agreed to the proposed settlement by the two parties, Mr. William Ato Essien should be made to pay the agreed amount in the current exchange rate with interest and not paying the same amount which has devalued. He indicated that it must not be done for it to appear that the accused has outweighed the prosecution, and that will not be full restitution but a partial one. The judge wondered that after 3 years of deployment of state resources, if the accused and the Republic would come to such a settlement, then it would have been a waste of time and resources of the state. Deputy Attorney General Alfred Fian-Yeboah, who represented the state together with other state attorneys, says they will comply with what the court has said, but their intention was to recover the lost monies to the state.
It's within the right of the judge to either accept or reject. Because looking at Section 35, even the parties agree, it's subject to satisfaction of the court. And the judge's wisdom has realized that there's a need to look at 1 or 2 issues. So you see nothing wrong with the judge trying to assert his authority as a judge in the case.
The judge basically said that this was a bad deal. Couldn't you have gotten something better?
Oh, it's a matter of negotiation. And you know, if you're looking at a case involving an accused person and the person makes a proposal, you also look at the proposal, consider, because let's take it. If you take a matter to court, it doesn't mean automatically you're going to have whatever that you are supposed to have. You need to bargain. We came to 90 million, but they just said if there's a need to up it or do something extra, we have no problem with it because it's a duty of the judge to scrutinize agreements reached by parties.
So you are now going back to the negotiation team?
Yeah, we are looking at the ruling. Perhaps we may go back or we may leave it to the judge to decide.
The judge made a very profound statement that if you'd allowed him to have given his judgment, he would have probably convicted the accused person. He would have gotten whatever he wanted. Why didn't you go through that process? I
think the judge's wisdom decided to adjourn. He made a proposal for the adjournment to the 8th. He later came to the 13th. So it's within his wisdom because we never prayed for an adjournment. Because after we would have said he was ready to deliver the judgment and we would have taken it like that. But he said he wanted to adjourn for the parties to consider the agreement again. We are not in any way aggrieved by the ruling by the judge. But that's
in all these things, the AG has been stating that he wants to ensure that money that the state owes gets it back. Is this all part of the plan?
Yes, in fact, that's the plan. Because you have instances where people have been convicted involving huge sums of money. They are sentenced, they go to prison, they say they have not recovered anything, we lose. So at times, if you are bargaining, there's a possibility that you can recover something, you need to also take a step. I stated somewhere at the last month that in all this banking crisis, our idea is to prosecute and, if possible, recover. If there's a possibility of recovering, as in the instant case, if the judge agrees with us, then we have to go along that route.
The judge talked about timing, and we know that sometime within the trial, the accused person had indicated that he wanted to refund some amount of money. Why has it taken this long?
It is true. The accused started making the offers to the Attorney General's office long ago, but we were not comfortable or agreeable to the figures that he was proposing. So that's why it took him all this while up to the last point of the prosecution. And we never relented in our effort to prosecute the accused persons. Despite the overtures that the first accused person made to us, we continued to prosecute the case. We got to the end of the case. Then he brought in this last minute proposal we thought was quite reasonable, but of course subject to satisfaction of the court. So the first accused especially, didn't start his negotiation yesterday. He's been coming and then going, but it's rather maybe to his benefit that the last proposal that he made we accepted. Should
we expect a better deal on the 13th point?
We are going to look at the figures again. Then we look at the options again. Two things. Either we have a better one or we drop the whole thing for the judge to proceed with the matter and then we look at where the ask falls.
The court adjourned proceedings to the 13th of December for the parties to convince the court on the issues that have been raised. William Ato Essien, Reverend Fijilad Odonko, and Tetenete, a former managing director of MC Management Service owned by Mr. Essien, were charged with 23 counts of conspiracy to stealing from 620 million liquidity support given to the bank by the Bank of Ghana.